Trump got his New York bond reduced to $175 million. Judge Enderon ruling that Trump owes $354 million has now been appealed. Judge Enderon made discretionary rulings, including Trump's Mar-a-Lago is really only worth between $18 million and $27.5 million. What the hell is happening? Hello, all you beautiful people, world's okayest lawyer here. Before I get started, I want to point out that I am not a big Trump fan, but I am a fan of justice. I do not believe justice was served in the Trump's New York fraud case. Stick with me and I will explain. We're going to start with Judge Enderon's discretion. The standards and principles governing judicial discretion in New York generally allow for broad discretion on the part of the judge, with the caveat that the decision must have a rational basis and not be arbitrary or capricious. Abuse of discretion is found when the decision shocks the judicial conscience. An aspect of the case where I think Trump could potentially get the civil suit overturned is in Judge Enderon's own words, where he called Trump a bad guy. The actual quote in open court, I want to point out, is if Miss James, that means the prosecutor, has a thing against him, okay, that's not in my understanding of unlawful discrimination. He's just a bad guy she should go after as the chief law enforcement officer of the state. And this was when Trump's team was trying to say that he was being discriminated against based off of his political beliefs of being a Republican. As a judge, Judge Enderon's duty is to be a fair arbiter of the law, and adding his own opinion about Trump, whether fair or not, is a breach of his judicial duty and capacity. Another aspect of the case that I think may not stand up on appeal, including if the appeal is to be taken up by the U.S. Supreme Court, is whether Judge Enderon's discretion of the value of Mar-a-Lago, even against the assessments of Trump's attorneys, along with the valuation provided by Deutsche Bank. As is the case in every real estate valuation, an owner of a property will attempt to claim the value of the property is high. It is worth this much money. A potential buyer then attempts to negotiate a lower price and maybe even some concessions by stating, well, it's not this high, it's this high. So whether that's $1 billion, $500,000, $100,000 house, it doesn't matter the value. When a person puts up their property or obtains for example, a home equity loan, they are going to say, hey, everything is worth way up here. It might really be here, but in this case, Judge Enderon said it was way down here. And I'm going to explain that more here in a bit. Lastly, Judge Enderon issued a ruling that Trump was barred from running a New York company and obtaining a loan from a New York bank for 3 years. The same restrictions apply to his adult sons for 2 years. The judge also extended the appointment of an independent monitor, a watchful outsider to keep an eye on the family business. This was an interesting determination, particularly in light of the comments made by Judge Enderon, along with ignoring significant evidence to the contrary of his own discretionary decisions. What also makes this case so interesting is that the state provided their evidence of the valuation of Mar-a-Lago and dismissed any evidence provided to the contrary. So I, who am not a real estate person, did some searching around for valuations of properties around Mar-a-Lago. And if you did not know, the street the property is situated on is called Billionaires Row. There is an open, uncleared property right next to Mar-a-Lago that the current asking price is $150 million. Granted, it is about a 2-acre property in comparison to Mar-a-Lago, which is a hair under an acre. However, just in viewing this aspect of the property valuation, that would put the land Mar-a-Lago is on at around $75 million, and that's excluding the actual building or buildings that are on the property. Now, there has been presented an issue in trial that Trump defrauded Deutsche Bank because of the tax assessment of the value of the property. To give perspective, the $150 million property that I just discussed last had a posted valuation of $4.4 million in 2020 as far as the tax valuation. That is a huge difference. So are they committing fraud if the property is up for sale for $150 million, but its last posted tax evaluation is $4.4 million? I don't think so. I mean, that's up to the state or the county or the city to make a determination of what they think the fair tax evaluation of the property is. According to Zillow, which is not necessarily a great tool, but they're at least more on the pulse than a judge in New York about Florida property, Mar-a-Lago has a zestimate of $162.3 million. And if you're not familiar with Zillow, what they do is they provide an estimate of the valuation of the property, but they call it a zestimate. The property next door to Mar-a-Lago has a zestimate of $138.3 million. The property next to that one has a zestimate of $92.5 million. I think you get the point that I am making. There is no way Mar-a-Lago, even with the historical property aspect to it, is merely worth $18 million to $27.5 million. If that was really the valuation of it, hey, I need to find some friends and let's go put in a bid for Mar-a-Lago, because that would be a smoking deal. I believe an appellate court, whether in the state of New York or the U.S. Supreme Court, will determine that discretion shocks the conscience, especially in light of Judge Endiron's own assessment of Trump. In addition, there are also news sources that have debunked this determination by providing articles from real estate experts on what they believe the value of Mar-a-Lago is, which is more in line with Zillow. Now, I will say, Trump has been attempting to claim Mar-a-Lago is worth over $1 billion. That just seems like bombast, and I'm going to call all cap on that notion. It is not a $1 billion property, particularly as there's no other property that is around around Mar-a-Lago that is anywhere in the valuation of $1 billion. He would have a really hard time attempting to sell Mar-a-Lago for that price. After the ruling on the case, news medias were explaining to the public that Trump was going to have to put up a bond for $454 million, which is a lot of money, even for a paper billionaire, which is what Trump is. Let's be honest, not everyone is Elon Musk, who can just drop crazy money and not bat an eye. Trump's money is mostly tied into real estate, so that's why I call him a paper billionaire. He is not a liquid billionaire, which means that he's just got $1 billion sitting in his safe and he can just go, boom, I'm going to go make it rain and go pay this bond. The appellate court reduced the bond to $175 million, which is a much more manageable bond, not just for Trump, but for a bond company that will take on the risk that Trump will lose the appeal. In addition, the appellate court also paused the aspect of the lower court ruling that barred Trump and his sons from running a New York-based company, along with obtaining loans from a New York-based bank. In addition, they also paused the monitoring of Trump Corp. Trump was able to secure a bond through Knight Specialty Group, preventing the state of New York from taking any of his properties until an upper court makes a final ruling and Trump runs out of appeals. So how can the U.S. Supreme Court potentially review the Trump fraud case, which is wholly based on New York law? As a review, here are the 5 bases that the Supreme Court can review cases. Federal question. When a state court decision implicates a federal question, meaning it involves the interpretation or application of the U.S. Constitution, a federal statute or federal treaty, this can be the case even if the heart of the case involves state law issues. If the decision also rests on a determination regarding federal law, the Supreme Court may review the case to settle the federal question. 2. Constitutional issues. The U.S. Supreme Court will review a state court decision if there is an assertion that a state law or state constitutional provision is in conflict with the U.S. Constitution. Areas often include due process, equal protection, or other individual right guarantees. 3. Preemption. If there is a claim that a state law is preempted by federal law, meaning that the federal law is supposed to take the place of state law in a particular area. 4. Habeas corpus, this is what you generally hear from state prisoners. Not going to really go into that. 5, adequate and independent state grounds doctrine. The court typically does not review cases that rest on adequate and independent state grounds. This doctrine comes into play when the state court ruling is based on a state law ground that is separate from any federal ground and is fully sufficient to support the judgment. However, there might be exceptions where the interpretation of state law is itself at issue in terms of compliance with federal requirements or rights. If the state court case does not involve any claims under the U.S. Constitution, federal laws, or treaties, and instead rests solely on issues of state law with no federal interest, the decision of the state's highest court is both the first and last word on the subject. The case would not be subject to review by the U.S. Supreme Court. Where I believe that SCOTUS could potentially review the case is under federal question. The reason for it is that whenever you have a bank loan, there are federal laws that are associated with it. And Trump's legal team could bring the case up to the Supreme Court saying, hey, the state of New York, including all the way up to this state of New York's highest court, wholly ignored the federal aspect of the business loan that was obtained in order to, make wholly state decisions. Because there are federal issues with this case is ripe for a federal question for you to review whether or not this taking that the state of New York is attempting to do is unconstitutional. The other issue is under constitutional issues, preemption, and adequate independent state grounds. So the constitutional issue in this case is a taking, meaning that the state of New York is trying to take property, including money from Trump. Trump's team is likely to argue that the state court is breaching his constitutional rights by arbitrarily finding and attempting to take his property in lieu of facts that show that Trump was above board throughout the loan with Deutsche Bank. As an aside, the loan was actually paid in full, making this case even more interesting from a constitutional standpoint. Preemption. If you have ever taken out a loan, you will find that there are aspects to the contract that meet both state and federal law. For example, federal regulations in bank loans, including the Truth in Lending Act, Equal Credit Opportunity Act, Fair Credit Opportunity Act, etc., etc., etc. This is not an exhaustive list. Because the loan would have federal regulations tied to it, Trump's legal team could potentially appeal the case to SCOTUS under preemption. Under the doctrine of adequate and independent state grounds, there are cases that would favor Trump's legal team. Now, I do think that this would probably not be the first thing that their legal team is going to argue. It would be more down towards the bottom of these are, some other aspects of the case that, should be ripe for the Supreme Court to review this. So in Oregon v. Haas, which is a 1975 case, the Supreme Court held that the adequate and independent state grounds doctrine does not allow a state procedural rule to preclude consideration of a federal question that is properly presented. So, hey, Supreme Court, we have federal issues in this case in addition to the state grounds, and the state never reviewed the federal grounds. We are asking you to review the federal grounds. The second is DeSys v. United States, and this is a 1969 case. The Supreme Court explained that when a state law ground is so intermingled with federal law that the state law claim is not independent of the federal claim, the Supreme Court can review the decision. Again, this case is about fraud on a loan application that has both state law and federal laws that are tied into it. They're intermingled. And Judge Enderon didn't really make a determination regarding it. He was more focused on the fact that state law allows for the state of New York to take from somebody if they can show fraud, which I'm not going to really discuss it in here, but proving fraud is a very high bar. And I don't think that was made in this case either. So what this all means is, in this case, is that Trump's legal team could argue that state grounds for ruling against Trump precluded the federal questions. Because the bank loans also have a basis in federal law, they are all intermingled, it's not independent, and it's ripe for a federal claim. Now, as I said earlier, Not a Trump fan. There are probably other areas that Trump could be successfully sued and on constitutional grounds. I just see this case as being too arbitrary and not based on justice, which is what I am all about. I did not become a lawyer just to make a bunch of money. I became a lawyer for justice, to try to help people. Like what I had to say? Please be sure to follow, like, and subscribe to me on whatever social media you saw this posted. I cannot thank you enough for listening to what my World's Okay's opinions are. Lastly, it costs $0 to be kind. It's the best money that you're ever going to spend. Until next time, beautiful people, peace.